The next matter is HB 905. Representative Ballinger, are you ready? Okay, well, come on up.
Thank you, Mr. Chairman. There are just a few, there were a few minor changes that were made to the bill. Do you want me to go over the changes or just go through it again?
I'd like you to go through the changes.
Okay.
And also the addition. The
Okay. All right.
The grafting, I guess
Yep.
you'd call it.
Certainly, I will.
All right, and let's start by identifying the LC.
Okay, I'm sorry, I'm working from LC 297105S.
That's same as we are, so
Mhm.
we're on the same page.
Sweet. That's always an improvement. So the first change that we made, there was some concern about the County Department of Ed. So on line 235, we actually changed that to each Board of Education as far as eligibility to the Child Abuse Protocol Committee. So that was the substantive change there. Now, whenever we get into the appeals process, let me, on line 651, we basically changed that upon a finding there is no credible evidence that the individual who requested the hearing is the individual who had a substantiated case. We added that language in there. Those were the two minor tweaks that we had to the language. Now we'll go into the substantive portion of the change. Basically, it begins on section 5 at lines 330. This was a consent, this was an item that, a bill that actually originated in the House. It was originally 915. And I'll just kind of walk you through some of those. It basically creates a Child Welfare Agency public scorecard. It's the fruition of a study committee that came out of the House. It basically allows the state to develop a mechanism for developing best practices among child welfare agencies and make decisions based on them. It also allows for a more organized inspection process. On lines 330 to 339, it defines the terms. On lines 340 to 377, it outlines the development of the Child Welfare Agency scorecard, specifically 340 to 343, direction to DHS and others to establish the Child Welfare scorecard. 344 to 350 is the publication of the scorecard and the explanation, in addition to whether or not that decision was appealed. 351 to 355 specifies scores based on a published formula that will be promulgated by the department and based on that specific agency's compliance with directed outcomes. 356 through 370 provides agencies with an appeals process if they wish to contest their score, and 371 through 377 is allowance for the rules to be established by the department. Lines 384, it changes the fine amount. 392 to 393. Again, it just restates the changes to the fine amount. Section 7, line 407 to 421, it defines the terms in the agencies. And line 422 to 433, it allows for a coordinated inspection process for all child welfare agencies. 434 to 439 is the appeals process for the inspected agency. 440 to 443 is no limit to the inspections or hindrance. So the idea of a coordinated inspections process does not necessarily limit were there to be an implication or some suggestion of wrongdoing by that agency. There's no limit there. And 447 to 450 is no limit to the agency's ability to contract. So that is the substantively, that is the significant change that was made in addition to those two minor changes that were made. I'll be happy to answer any questions.
This was originally Representative Welch.
Yes, it was. Chairman
Yeah.
Welch. It was originally House Bill 915. It passed unanimously through the Health and Human Services. It's a consent bill. I know Ashley Fielding with DFACS and DHS is here, as is, and it's also supported by Voices for Georgia's Children, Office of the Child Advocate, Barton Center.
All right. Did not see anyone signed up. Did anyone want to be heard on HB 905? Okay. Are there any questions for Representative Ballinger from the committee? Senator Bethel.
Thank you, Mr. Chairman. Just as a word of confirmation, and thank you to Representative Welch for his work on this. I just want to confirm that the language that's in sections 5, 6, and 7 is without any, other than the numerical differences,
Yes.
it is what passed Health and Human Services in the House
It
without
is.
any substantive difference.
Yes, it is.
Thank you.
And it is agreed to by, Ashley is actually sitting back there and is happy to answer any questions, but it is a consent by the agency.
Thank you, Mr. Chairman.
All right. See no further questions. What's the pleasure of the committee? We still have a, do we have, we got 5. All right. Motion made by Senator Bethel, seconded by Senator Jones. All in favor signify by saying aye. Aye. All opposed, like sign. Okay, it passes. Who's carrying it?
Senator Bethel.
Thank you very much.
Thank you.
All right, that brings us to the third item on the agenda. HB 941, Representative Golick, who said that he could not be here. So we've got a number of people signed up to be heard, and as I indicated, this will, we are reopening the public comment period and anticipate possibly further changes. We will take up this bill at our regular meeting tomorrow. Do not intend to take any public comment tomorrow. All right, the first person signed up to speak. Now, before we get started, because of the number that we have signed up, we're going to limit generally to 3 minutes per person, as we have in prior public comment meetings. And if you have already spoken previously at our previous meeting, then we may or may not hear from you. We don't want repetitive statements. But the first person I have is Lance LaRusso, Attorney General Counsel with Georgia Fraternal Order of the Police. Okay. Good
Thank you, Mr. Chairman.
afternoon.
Good afternoon. Earlier, when I did speak about this bill, there was one issue that was not brought up.
Can I stop you?
Yes, sir.
My aides up here have indicated that I have neglected to announce we have 2 subs that have been presented that we're not voting on today, but for the public's benefit. They are LC 297111 ERS and LC 297108 ERS. And we may have another one tomorrow. I've been informed, so we'll see. Sorry to interrupt.
Not at all, Mr. Chairman. Thank you. When I spoke to you last time, one of the things that I did not bring up, and there were some questions about it, it's not just the fact that OCGA 17420 discusses the officer's reasonable expectations as to why they use force that a grand jury needs to hear from. But in addition, United States Supreme Court precedent in 1983, the Graham versus Connor case, discussed how an officer's actions should be judged. And in that case, the court said that the actions of the officer have to be judged from those of a reasonable police officer, not a reasonable person. That is a very different standard than we use in every other aspect of criminal law. And in that standard, the statements of the officer, the training of the officer, the perceptions and the reasonable beliefs of the officer must be considered. And in the interest of time, the other thing I would like to address, we stand against strongly any effort to automatically recuse prosecutors from these cases, and I'll tell you why. It's easy and it's enticing to say that any time you have a case involving a law enforcement officer, we need to recuse anyone who has any contact with that officer. But there's a mechanics that people forget involving these cases. If you bring a conflict prosecutor, and I'll let the prosecutors talk about the cost and the logistics, but if you bring a conflict prosecutor in, right now this bill has some very hard-worked, negotiated provisions to have a transcript of everything that happens. So you bring a conflict prosecutor in, and the result is upsetting to people. The result is conflict contrary to what people think should have happened. Let me tell you how much accountability that conflict prosecutor will have to the people in that community. Absolutely none. You can't vote them out. You can't get somebody to run against them. You can't even run into them and give them a piece of your mind at a Little League game or church because they don't live there. They're not involved with the people in that community. There is no accountability. It's very easy to think about that as being an answer, but the bottom line is we trust these prosecutors to make decisions every day regarding the prosecution of all other public officials. And when we talk about conflicts of interest, people look at them every day and they handle them. I'm preaching to the choir when I'm dealing with the senators that are sitting here. You have rules that you have to act according to, and so the prosecutors. They have conflict rules. But if we start out with a premise that every one of the DAs in this state is biased when there's a law enforcement officer being brought up on charges or their use of force is being reviewed, then we are straying far from what our system was designed to do. Thank you.
Let me ask a question. Do you not see a possible argument that there's a perception of bias or with the public?
I do, and that's one of the reasons why we pushed to make sure that there was a transcript that went through it. I have sat with officers on grand juries, and I've seen prosecutors do things that I didn't like, that I think that were completely improper. And that's one of the reasons why I said there needs to be a transcript. It's not anybody's interpretation. You can read it on a transcript and a record to decide what was done was proper. The problem is, I also worked as a law enforcement officer. And I know that if a law enforcement officer does something improper, it's not something that you hear about all the time. But I will tell you that the DAs take action against those officers. They go back to their chiefs when they see that they're doing things improperly. And we don't hear about that in the paper, and we don't read about that very often. But it happens every day. It happens from the perspective of training, and it happens from the perspective of discipline.
Thank you.
Thanks,
sir. Don't go anywhere. Senator Fort.
The trust of the public is at risk. There's no legislator up here on the Senate side or on the House side has talked to more families who I've talked to the Ariston Waiters family. I've talked to Baby Boo Boo's family, the Fonsavon family. There's no legislator up here who, I've been not only here at the Capitol, but in the streets with people who have been victimized. And it is one thing for people to tell me about accountability and how, the buck stops with the district attorney. Well, the fact of the matter, too often the buck has not stopped there. I've seen what these situations do to families. I've been on the picket line, but I've also understand the police are in the most dangerous, thankless job in this country, pretty much. But at the same time, it is not enough. It is not enough to say, let the district attorney be held accountable. It's not enough because lives are being lost out here that don't need to be lost. And I am just at the point, where I'm telling you, if we keep doing things here at the state capitol and don't address the concerns that are out there outside of this gold dome, then we are at risk of the community losing all of its trust. The people that I serve, I'm talking about the people that I serve, that I hear from every day. And so, if a special prosecutor is not the answer, then you tell me what the answer is. You tell me what the answer is. Because I don't want to sit with another family who's lost a loved one in a way that we all know is wrong. That's all I wanted to say, Mr.
Thank you.
Would you like me to respond, sir? Or?
Certainly.
In January, a DeKalb County police officer was indicted by a DA who was elected in that community. In addition, Senator, one of the problems there has been is there is no way for anyone in the public after those cases are resolved to find out what the DA actually did and hold them accountable. And that transcript will go a long way to do so.
Let
Thank
me ask you one question that came to mind. The reasonable police officer standard, that's
Yes, sir.
set by a
United States
Court.
Supreme Court, Graham versus Connor, Graham versus Connor, Connor, 1983 was the year of the case.
Thank you. Thank you very much.
Thanks.
Next, we have signed up to speak Dr. Bill Hudson with Restore, Preserve, and Preserve the Constitution.
Chairman,
Good afternoon.
how are you?
I'm fine.
Good. I'm Dr. Bill Hudson. I'm with Restore and Preserve the Constitution, and I appreciate getting a chance to speak here before the committee, chairman, members. I've studied the proposal of the HB 941 committee substitute, and I'm asking to request that you take no action on this bill or the substitute because both bills achieve the opposite effect from the author's stated intent and will make both make a bad situation in Georgia worse. Both bills propose new unconstitutional double standards that violate equal protection clauses in the U.S. and Georgia constitutions, which seems to be this body didn't think about that or care about that at all. Neither bill corrects the current Georgia language that violates the clear, plain text of the equal protection clauses of the Georgia Constitution. The General Assembly lacks constitutional authority to legislate grand jury procedures. And that's what they're doing when they're letting the DA basically run the grand jury. 171 Georgians have been killed by law enforcement officials, none of whom were prosecuted. That's a horrible record, and this bill substitute doesn't do anything to fix it. The AJC did that study. Many of those Georgians that were killed had no criminal record, were unarmed, were shot in the back, and were murdered by officers who broke into their homes. Study concluded that the grand jury investigations were hampered by prosecutorial misconduct and unequal double standards. And I believe that's what happened in the David Hooks case when it was investigated by a special prosecutor down there that didn't do his job. Purpose of the grand jury is to determine whether there's a probable cause to charge a person with a crime, not to determine guilt or innocence in the mini trial. These DAs end up, by controlling the grand jury to get them to do what they want, they end up acting as the Leo's defense attorney by stifling the grand jury from doing its job when they're in these, that's how the mini trial happens. No other state has such a double standard because it violates equal protection clause of the U.S. state constitutions, including Georgia. The bill has no clause to prohibit officers from attending the entire hearing. It merely designates when the officer can testify. The bill allows officers to refuse to answer all questions when cross-examined. They weren't allowed to be cross-examined before. Now they can be cross-examined, but they don't have to say anything. At least 10 new double standards that will further subvert the current grand jury process are in the substitute. Special prosecutor substitute language allows the appointment of special prosecutor, supposedly intended to provide more independence when investigating cases involving a peace officer. However, an appointed prosecutor has no accountability to the people for the investigation since the prosecutor is not elected. And that was discussed previously, but I'm not sure that the special prosecutor is the answer. And the general prosecutors and the general procedures proposed in 941, having already been employed in the investigation of the murder of David Hooks, I believe there's prosecutorial misconduct there. Prosecutor and procedures failed to return any type of indictment in the case. inconceivable if there was not enough probable cause to return a true bill for a faulty search warrant that was issued. The Lawrence County deputy took the word of a burglar and a meth addict, and then they busted in and killed Mr. Hooks. Unconstitutionality, both the original 941 and the Senate committee substitute retain existing language that establishes a special class for peace officers. The bill continues to allow them to be notified of grand jury, testify before the grand jury, and to have an attorney present. That attorney ends up acting as their defense attorney in a lot of cases. No other class of Georgians has such a right, has such rights if investigated by a grand jury. Bills proposed previously described double standards to further shield officers from prosecution when they commit murder or other serious crimes. None of these exceptions to the normal grand jury process are offered to other Georgia citizens. HB 941, its committee substitute, violate the clear and plain text of the Equal Protection Clauses, the 14th Amendment of the U.S. and the
Okay.
first article of the Georgia Constitution.
Can you wrap it up?
Okay. The conclusion is the solution to help solve the problem of the 171 shot dead and 0 prosecuted folks is to simply strike about a half dozen small paragraphs that provide the double standards in the current code. Neither House Bill 941 nor the committee substitute propose to do this right thing.
All right, just for clarification, both of the substitutes that I alluded to earlier have removed the presence of the testifying officer, just for your,
They've removed the test, yeah, well, when he
Right.
couldn't testify before, that was the only state to do it. Now they were gonna put it in there where he could, but then he can take the 5th, so it didn't ever matter.
right.
Thank
Well,
you.
thank you very much. There are no questions. Nicholas Messina.
Hello, my name is Nick Messina. I live in Woodstock, Georgia. As you can probably tell by my accent, I'm not originally a Georgian. I don't know if that's a bad thing or a good thing, but I'm also not a politician and I'm not an attorney, so I can't argue the facts that are going back and forth here. The one thing I can give you is personal experience. I'm sorry to say that as I look across this group of people, sir, you know, you're talking about laws and you're talking about amendments and was this T crossed and was this I dotted? What you're lacking is humanity and understanding that the laws you pass affect human lives. And the things that you talk about here are not just empirical, they're not just experiments, they're not just theory. The things that you do here pass down to the people. On May 1st, 2012, my son was shot and killed by a cop. And I apologize to anybody in the audience who doesn't like the word cop, but he was shot and killed by a cop.
When was that?
May 1st, 2012, sir. And the fact that I stayed virtually 300 feet away and watched him die and bleed to death, and I couldn't even be there to comfort him, will always be something that none of you will ever understand. But then I had to go through the humiliation that my son's death didn't mean a damn thing to anybody, that they didn't even bother to call a grand jury and to investigate. They rubber stamped. And the man who shot my son today is still walking the street. I don't know if he's guilty of anything or not, but I do know that this law, just like the law that I sat in front of you people last year and talked to about, when you wanted to allow people to bang through doors and basically execute these no-knock warrants. And I said here, and if nobody remembers me because that's how much you're paying attention, but the fact remains that I said that it would cost lives. And sure enough, if I'm not mistaken, a police officer lost his life this year by serving a no-knock warrant. Okay? And the fact that you're not taking into consideration that the laws you pass affect human lives. I am 61 years old. I grew up in a city that makes Woodstock, Georgia look like a carnival. I grew up in Philadelphia, Pennsylvania. And I grew up during the 60s and 70s when not my city almost burned to the ground, and if it hadn't been for the police. I respect police. I have more police in my family and friends than probably anyone here. And even back then, when a Philadelphia cop would crack your head just as much as look at you, they still had humanity. They still were people that you loved and respected. And they did everything to conserve life. What I see now are police officers who kill first and take care of the details later. I don't know where that starts and ends. But something has to be done. Okay? That man right there said that he spoke to people in his community that have been the victims of police abuse and using excessive force. My son died in Cherokee County in 2012, and none of my politicians came to see me. So maybe you people need to go out into the community and talk to the people that are affected by this before you sit here and just look at your laws and shuffle your papers and pass laws because some pact or some people sitting back here are the people that are going to vote for you. I'll also tell you this. He's right that the people in his community are affected by it. I'm the epitome of white, middle-class America, and no one expected someone like my son to get shot the way he did, okay? And if anything can be taken from this, that it's not a black problem, it's not a poor problem, it's not a people with mental issues, it's our problem. And you people need to solve it.
Thank you very much.
Thank you.
Next, Oliver Hunter. Good afternoon.
Good afternoon, Mr. Chairman and the committee. My name is Attorney Oliver Hunter. I represent the Political Action Committee of the Alpha Phi Alpha fraternity, over 7,000 members here in Georgia. And I'd like to speak to the proposed amendment 710 ERS, 710H rather, ERS. Okay. I first would like to simply say that no one has a greater appreciation of the work of the district attorneys and the law enforcement than I do. But this issue isn't really about them. It's about a system that is broken and losing respect in the communities every single day. Voters are angry, and much of it is because of issues like this when they feel their voices are not being heard. I don't think this is a Democratic issue or a Republican issue. It's not a black issue. It's not a white issue. This is the issues about the people of this community who feel their voices are not being heard and who feel that the presence of a special prosecutor will tremendously aid in the delivery of justice. There's a widespread perception that the relationship that exists between the district attorney and those in the law enforcement community is one that causes the appearance of impropriety. It's not about necessarily the bias that may or may not be there. It's about a system that cannot be trusted. Our system depends upon the trust of its citizens. And frankly, people don't trust the system. And I don't know how many of you get a chance to talk to everyday people, but there is a widespread perception that the relationship is too cozy. So I stand in my place and representing over 7,000 members of my organization and ask this committee to please adopt a provision that will require the appointment of a special prosecutor in all those cases in which a serious bodily injury or death occurs at the hands of a police officer. And that's simply our position. We think that it serves the interests of everyone.
Keep your seat, Senator Fort.
Yeah. Do you know that the governor right now can appoint a special prosecutor if a school system, if he believes the school system is violating testing rules and regulations as they did with APS? that a special prosecutor with investigators was appointed in that case. Did you know that?
I believe that's correct, yes, sir.
And do you further believe that if we can appoint a special prosecutor to investigate test cheating, we ought to be able to appoint a prosecutor to investigate the death of a Georgia citizen?
I do. I think that's no more important issue. I mean, this is an issue that is not going to go away. The folks and the people I represent, they aren't going to go away either. And they're going to continue to press for this, just perhaps more fiercely. But this is an issue that we cannot sweep under the rug and pretend that it's not here. It is an ever-present issue until we get the political courage to address it face on, head on. I think we're going to be dealing with these issues and possible repercussions from the failure to take actions.
Thank you very much.
Thank you.
Next person signed up to speak is Gerald Griggs, NAACP attorney. Yes. Good afternoon.
Chairman. Good afternoon, members. And it's a pleasure to speak again. And I just want to echo the sentiments of Mr. Hunter and the gentleman who unfortunately lost his son's life. As you know, I represent the NAACP, both the city of Atlanta's branch and the Georgia branch. We don't have to tell you how many members we have, but this is an issue that touches our hearts and our people every single day. And I do know that members of the Prosecuting Council of Georgia are behind me, most of which I respect. Members of law enforcement are behind me, most of which I respect. But this is not about law enforcement. This is not about members of the Prosecuting Council of Georgia. This is about the citizens of Georgia that are being disproportionately killed with no accountability for law enforcement. Now, previously when I spoke before you, I asked you to vote this bill down. I know now that there's enough votes for this bill to pass. So all I'm asking you as a member of the bar and also a member and the vice president of the NAACP and the chair of the Georgia Criminal Justice Committee of the Georgia NAACP is to add a special prosecutor. It's not going to cost more money. It's not going to take more time, and it's going to at least give some amount of accountability and trust to the system by the people that I represent. So I'm asking you to do that because just like Mr. Hunter said, we're not going to stop pushing on this issue. We're still going to be on this issue, but we need something that puts us in a better place than we were before. Now, again, I still think there are a lot of needs in this particular bill that need to be addressed. One, I don't believe a law enforcement officer hasn't any placed in a grand jury. But the appointment of a special prosecutor, and as was just asked by Senator Ford, there's only one person in this room who knows what it's like for the governor to appoint special prosecutors and go through an 8-month trial, and that would be me. I sat through that trial. I know the possibility and the amount of energy that it takes. So if it's truly about protecting Georgians, you will add that special prosecutor and you will pass that amendment. Thank you.
No oh, wait, excuse me. We do have a question. Senator Jones?
Yes. I would like to address, one of the issues about the accountability issue.
Okay.
Let's say that special prosecutor does get appointed.
Yes.
And it's a metro area, whether Augusta, Atlanta, and a special prosecutor comes from, let's say, a more rural kind of area, and that special prosecutor does not indict. And what's your response to when the persons or people say, well, wait a minute, if they would have been from Metro Atlanta or Metro Augusta, they would have understood more about what was going on and they could have presented a better case. How do you kind of address that issue that the accountability may be lost because the special prosecutor won't be from that particular area, and that plays a role into how things are done?
That's true, and as I said, this bill, like I said before, it doesn't go far enough. And those are some considerations that we have to make, and hopefully the Prosecuting Council of Georgia would see fit to appoint somebody who understands the dynamics of that particular area, and they are holding themselves accountable. But I don't know. I honestly don't know. But representing the people that I represent, there is a serious distrust, and there needs to be some amount of transparency in this system. Otherwise, we're going to have a really big problem. So I don't really know how to address that particular portion. That'd be something I think the Prosecuting Counsel of Georgia could better address, but we need to do something and do something immediately.
All right, we have another question, Senator.
Attorney Griggs,
Yes.
isn't it true that while we pursue perfection,
Yes,
perfection is not achievable?
that is true.
Isn't it true that a special prosecutor is not a perfect solution,
No,
but
it's
that
not.
it may be more likely, maybe a little bit more likely, but more likely that a special prosecutor would be able to function in an atmosphere that is less prejudicial, particularly as far as political pressure is concerned?
Yeah, definitely. I think the special prosecutor wouldn't have the same pressures that an elected district attorney may have, considering their close relationship with the law enforcement in that community. So I think it takes away the appearance of impropriety. Now, I know as members of the bar, they would not do anything intentionally to violate their oath. But I think when political pressure is brought to bear, and their close relationship with law enforcement, I think it's necessary to have a special prosecutor at the least.
Thank you.
Thank you.
That's all we have. Questions. Next, Danny Porter and Brian Fortner. Y'all signed up together with Prosecuting Attorneys Council. Good afternoon.
Good morning, Mr. Chairman, members of the committee. My name is Brian Fortner. I'm the district attorney for Douglas County. I was here at the last meeting. I apologize for not speaking. However, at that point in time, we did not know that amendments were going to be proposed that were going to effectively recuse DAs outright as a matter of law. Because of all of the reasons that you've heard from so many people who've testified before you, this is a very, very important issue. I hope that the presence of the district attorneys here today, and I would ask that they all stand, please. We weren't going to have everybody speak. We know that would take too long. But they are here because we hear that this is an important issue, and because we recognize that this is an important issue. And although I am the DA of Douglas County, I was also selected by my peers to head a committee to address the way these cases were being handled, to attempt to rewrite the law because of all the problems that we've talked about here. And that's why House Bill 941 exists. House Bill 941 is a result of an effort by your elected DAs in recognition that the law appears to be unfair, that the public was losing credibility. For whatever you fall in this debate, it is a fact that our citizens are scared, our law enforcement officers are scared, and that is a recipe for disaster, and we needed to do something about it. And as your elected DAs, that's what we did. The entire point behind House Bill 941 is for transparency and accountability in the process. And I think we're losing in the argument the fact that this is a substantial step forward towards the ends of justice over what we have in the current law today. I think that's evidenced by the fact this was passed unanimously in the House and had bipartisan support who signed on to this piece of legislation. I respectfully submit that any amendment that removes an elected district attorney from handling these types of cases will completely undermine and destroy the accountability that we've worked so hard to create by this bill. The Constitution of the State of Georgia, Article 6, Section 8, Paragraph 1, establishes the responsibilities of a district attorney. Mr. Porter is going to talk about that. But I want to tell you that accountability flows from the very first sentence of that provision, because in its creation of the role of district attorney, it says that it will be elected by the voters. It will be elected by the voters. The people need to have a say. When they are in outrage, they need to have something that they can do about it. And so we set out to improve the system. Number one, I submit that there's accountability over the fact that now law enforcement officers specifically will not be allowed to be inside the grand jury when this is taking place. That is specifically spelled out in both of the amendments. It's more accountability because now the citizens who serve on our grand juries will have the right to question that law enforcement officer. The DAs will have a right to question that law enforcement officer. And when that law enforcement officer is done, we will have the right to call, and the grand jury will have the right to seek out witnesses in rebuttal. That's accountability in the hands of the people, and that's why the grand jury system is so important. As to the issue of transparency, right now we do not have mandatory transcripts in these particular cases. That is so important to establish accountability. We've heard about these cases that tear at our heartstrings. We've heard about them. What I can tell you about the Carolyn Smalls case, what I can tell you about these other cases is that under House Bill 941 and this piece of legislation that your DA's pushed for, you will have a transcript to know exactly what happened in that grand jury. You will have a transcript that tells you every single witness who was called, that every single word that is spoken in testimony, every single exhibit that is offered, and the citizens will be able to tell once and for all if a DA did something to thwart that case. And guess what they will have? They'll have the ability to do something about it, and they'll hold us accountable. And I'm asking the voters to do that, to hold us accountable. But imagine if you have that same transcript, except this time it was handled by a special prosecutor who is never going to be answerable to the people. That is a problem. We must not allow the legitimate, the warranted outrage and heartache over these cases cause us to grasp at a mirage of a solution. You've already heard somebody who stood up here and said and testified today that the special prosecutor was no solution, and they had the same problem. We're never going to be able to erase that. If you look at the recusal statute itself, it deals with perhaps the Attorney General's office can have that. The Attorney General works with law enforcement. Perhaps another DA can handle that. DAs work with law enforcement. There's always going to be that appearance. I think the worst thing that can happen is for us to take accountability away and take the voice of the people away. Because if they have no right to protest, if they have no right to go to the polls and hold that DA accountable, we have taken a major step backwards. And I think accountability is a very important issue, and that was the real impetus behind House Bill 941. The other thing I want to mention is an issue of practicality.
Kind of summarize.
Okay, I'll try my best. Mr. Chairman, I really appreciate this is a
May
major,
give you a
major
little
issue
extra
for us.
time if Danny doesn't have anything to say.
Yeah, he may not. Maybe I'll take some of his time. But
Mr. Chairman, have you ever known that to happen? And that's just a rhetorical
Go
question.
ahead.
one thing that I have to say, and I think we have to take a look at this as far as a practicality standpoint, because I know how these cases are handled. I know what happens. I know what resources are spent. The GBI is now investigating majority of these cases, but the GBI are fact finders. They do not take a position. So from the very beginning of one of these cases, I had one in December. Within hours, I was out on the scene as the DA. I was there meeting with the GBI to make sure they had all of the resources they needed. They were not getting any resistance from local law enforcement. I helped them in regards to looking over search warrants and doing their work and letting them know they had an office, an operation base, so to speak, in my office, and I was able to provide that support. That will be completely lost if we seek to replace a DA, because this takes time. And I submit to you that the recusal statute that we already have is already overburdened. It's already troublesome to find prosecutors to take on these cases because they have to leave their jurisdiction to go to another to be able to take on these cases. And these are the most important type of conflicts you could ever have. These cases are so important. They require hours and hours and hours and days and days and days because we have to reinvestigate them since the GBI does not take a position. So I simply want to say in closing that we support the substitute LC 29-7111 ERS, but we oppose any effort that will recuse local district attorneys from handling these most important cases in our jurisdiction, primarily because it takes accountability away and it will silence the voice of the people to do anything about a DA who does something wrong.
I have a question. I'm not clear on why. I can understand the extra cost argument, but what, you mentioned something about cooperation, reinvestigation.
Right.
Why would having a special prosecutor cause you to have reinvestigation?
No, I'm not saying that having a special prosecutor would cause you to have reinvestigation. I'm saying if you're going to appoint a special prosecutor, to suggest that that's not going to cost additional resources and additional time is simply not true. When I work these types of cases, I'm working one right now. I went out to the scene. What's going to happen when one of these happens on a Friday night and there is no special prosecutor that's been appointed? If you and the legislators by law recuse me from a case, I can have no role in it. Neither can anyone in my office. That has been made very clear by recent Supreme Court decisions. So we can't offer any support to the GBI at all. Nobody can until this procedure takes place and somebody can appoint a special prosecutor.
Thank you. We have a question, Senator Ligon.
Thank you, Mr. Chairman. I wanted to ask you a couple of questions about the accountability argument that
Yes,
you're raising.
Senator.
And I believe you mentioned that that you serve as a special prosecutor sometimes from time to time. All DAs do that.
All DAs could
Right.
be asked to do that, yes.
And it's a part of our law. I've never heard of there being an accountability issue in those circumstances. I mean, can you?
Senator, if I might, I don't want to horn in on his time, but I had actually that happen.
We already gave him your time.
I was appointed as a special prosecutor in the Appalachian Circuit one DA ago, and I went up and was asked to investigate a judge for a variety of reasons, including some issues with the JQC. I ended up closing that investigation without prosecution. I did it administratively, I wrote a letter, and I walked away. That DA, people in that circuit were really unhappy, But I was safe at home in Gwinnett.
But did you do your job?
Yes, sir, I did my
And
job.
you felt that you upheld your oath of office and
Yes,
you
sir.
did what was right and true, correct?
Yes, sir, but it became an issue in that DA's next election. And he had no recourse.
But
He
there
could only point to me and go,
Right.
Danny did it.
But so what you're saying is that there was a tremendous amount of political pressure to bring perhaps an action that should not be brought against the judge.
Not
But against the DA in that district. Is that what you're? That's what I hear you telling me.
No, I think that there wasn't political pressure. I think that there was criticism of the way that it was handled that he had no way to respond to.
But there would have been criticism because there was a desire from a certain section of the public to see something done to that judge that you were investigating. And so in that instance, the pressure works the other way. But the right thing, based on your investigation of the case, the right thing happened. And you were not susceptible to that political pressure. Is that correct?
Yes, sir, but I think the important thing to realize is that DA paid the price for my decision because he was voted out in the next
Right.
election. And I can't say that's the only reason, but it certainly was part of the campaign. And that's one of the concerning things. And I would say to Senator Ford, if you don't believe that accountability is an issue that can be held, the DeKalb County District Attorney's Office race that is being run right now, one of the main issues is the accountability of the current prosecutor for his handling of police-involved shootings. So it is an important issue to us as individuals and as elected officials.
Okay.
Right.
Senator Crane.
Thank you, Mr. Chairman. If we can maybe touch on a different kind of point of emphasis for a minute. I gather from you, Brian, that you like the transparency requirements that are introduced into law. I presume that's the feeling of all our DAs that look at it that same way, this reporting requirement, particularly in these use of force cases. I support that a lot too. One of my questions, and I get a lot of comment on this from constituents, is is there anything in the law, if we omitted section 17,752 and 4511.4 with regards to police officers, is there anything in Georgia's law that would prohibit the DAs from requesting the officers present in a grand jury proceeding?
I don't know that there's anything that would prohibit us from requesting their presence or for the grand jury requesting their presence, but I think we have to understand that what separates a law enforcement officer from an average citizen is 17.420. That's a statute, that's law that specifically authorizes the use of force in carrying out of their duties. It is not true to say that they are similarly situated as every other person, although we completely recognize the fact that the system has an appearance of being broken and something needs to be done about it. So our position is that addressing these rights that we felt were unfair for them to make a statement, no cross-examination, watch everybody else, all of that had to change, and we feel that we've reached the best result by removing those rights, allowing them to be there because they are specifically authorized by law to use that weapon in the course of their daily lives and carrying out their duties, but to restore balance to the process and to make sure there's transparency and that every single voter, everybody in the community, everybody concerned can see exactly what was done by a DA and in the presentation of those cases, and we do not have that now. That's why
Well,
we're speculating
let me
about
hold you there a
accountability.
second, Brian, if I may. I'm not sure that's exactly where I was going with my question. Let me try, and Danny, you can jump in if you want to on this.
I'm gonna give the lawyer's answer, it depends. If the district attorney proceeds on a criminal indictment that charges the officer with a crime, then no, you cannot compel the officer to come in. If you are proceeding under the civil grand jury that is envisioned by 941, the officer can be invited but can decline.
Well, that, you just said the same thing.
So the answer
You
is
said they can't be compelled, and you said they can't be compelled. You just said it two different ways. Is that a lawyer thing, too?
that's an unconscious thing.
Oh, it's just you're so conditioned to that. It just happens naturally. Is that right, Danny?
No, sir, I don't think it's that.
I didn't mean to imply anything. My point being is you can't force them to, but you're not excluding them. And if those sections of the codes were not obvious, those are the distortions in the code that seem unfair to many citizens. We don't have that immediate access. I wouldn't have that access to that grand jury, but I would bet in almost all cases, and the DAs could reinforce this or not, that you guys would ask their presence in any use of force case. Is that not correct?
I would,
Yeah.
yes.
Okay. Thank you. That's all I had, Mr. Chairman.
Now, Mr. Porter, do you have anything to add?
Well, I would add that the last argument that we would make, and I'd like to give a couple of examples, and for the record, my name is Danny Porter. I'm the chairman of the Prosecuting Attorneys Council. I'm here speaking on behalf of the district attorneys, and I want to make very clear that we as a group support House Bill 941 as passed out of the House. We are deeply concerned about any amendment that would recuse the district attorney as a matter of law in any case where serious injury or death occurred as a result of officer-involved action. And we base that, first of all, I think the amendment impermissibly divests the district attorney of duties that are set out in the Constitution. The Constitution of Georgia at Article 6, Section 8 says, Paragraph 1D, it shall be the duty of the district attorney to represent the state in all criminal cases in the Superior Court of such district attorney circuit and in all cases appealed from the Superior Court and the juvenile courts of that circuit to the Supreme Court and the Court of Appeals, and to perform other duties as shall be required by law. That, I think, is the baseline which cannot be, this legislature has no power to bring below. I think everybody here would agree that this legislature could not arbitrarily say that district attorneys are not permitted to prosecute burglary cases. That you make that decision for whatever reason you make, and that would be an unconstitutional statute. Our position is that to remove a category of cases that are potentially criminal cases from the power of the district attorney would render this statute vulnerable to a constitutional attack. And let me just tell you, the first officer who is indicted under this procedure, if the amendment passes, will certainly challenge the constitutionality of the statute. So we believe that the infirmity puts in danger the entire good work that was done in 941. The other, and I want to follow up a little bit on the practicality of this, because first of all, there was a misstatement by one of the witnesses. The Prosecuting Attorney's Council does not appoint conflict counsel. The Attorney General does. And the way the process works is that a prosecutor declares a conflict, and the Attorney General then searches out and appoints a prosecutor to handle that case in that jurisdiction. That prosecutor then assumes all of the duties and powers of the district attorney. All of us sitting in this room, the 20 district attorneys who are here today, have acted as a special prosecutor somewhere in this state. I've done it, Brian's done it, everybody's done it. It's part of our job of supporting one another, but I can tell you it's difficult. It's difficult to walk into a foreign jurisdiction. It's difficult to walk into a foreign jurisdiction and deal with law enforcement. It is difficult to deal with court systems, and it is 10 times as hard to be a special prosecutor as it is to be in your own home jurisdiction where you can handle that. But most importantly is these are the kinds of cases that I think we all agree that from beginning to end deserve a higher level of scrutiny. But we have to face the realities. Here in Atlanta, we're in Region 10 of the GBI. The average response time to an officer-involved shooting in the metropolitan Atlanta area is from 1 to 3 hours. We in Gwinnett, because we have the resources, have decided that we are going to, because our law enforcement agencies have requested GBI to investigate these cases, that if there is an officer-involved shooting, there is a response from my office. I or one of my senior assistants are on the scene. My investigators secure the scene. We locate witnesses. We draw up search warrants for the GBI. So that by the time GBI shows up, they're ready to go to work. They're ready to handle the case. In jurisdictions that are smaller, I can tell you at the very least, we have one DA here who has one assistant DA and one investigator. He makes himself available to his law enforcement for legal advice. And make no mistake, officer-involved shootings have some of the most complex legal issues that face law enforcement and prosecutors. First of all, there's the interplay between Miranda warnings, the Fifth Amendment right against self-incrimination, and garrity obligations where the officer can be compelled to give a statement. Georgia law is very clear that we have to make a distinction between a criminal investigation and an administrative investigation, and that officer can be forced to give a statement under garrity, but we can't know about it. And that information could contaminate a criminal investigation if there's not careful consideration and legal advice and legal support. There's also the questions of search warrants. When do you get a search warrant? How do you prepare that search warrant? How do you help those officers conduct legal searches? There's the recovery of evidence. There's the location of witnesses. There's all of those things that are necessary to a competent professional investigation, which in the time lag to appoint a special prosecutor will be lost. If they are lost, they're lost forever. And therefore, we think from a practical standpoint, the appointment of a special prosecutor, particularly in one of those cases where it's a non-firearm case, where you have a person who has been beaten by the police, who has been tasered by the police, and there's that time period where they may or may not pass away. In that case, the local district attorney is in limbo, awaiting whether or not that person could be classified as a serious injury and whether or not they're going to die. And we think
Mr. Porter, let me stop here. The substitute that has recusal language is limited to the death cases.
And that is exactly the issue that I'm bringing up. I mean, we have this perception that police officers shoot people and they die right there. But the reality is they don't. The reality is they can live for days, even weeks. And in that time, is the local district attorney going to supervise the investigation? We going to wait for the attorney general to appoint a special prosecutor? it is not an efficient way. I think what the net result is that we're gonna end up with less comprehensive investigations rather than more.
Okay.
And that is the fear that we have as prosecutors.
All right.
It has been my experience as a special prosecutor that the result is never satisfactory to either the citizens of the county or to anyone.
Okay, we have a question, Senator Ford.
Why, I understand your point that,
I'm sorry, Mr.
yeah,
I'm sorry.
that's
Mr.
okay. I understand what you said about a special prosecutor being unconstitutional in these instances.
Yes.
Now, why isn't it unconstitutional? I mean, right now, the governor, from what I understand, and an AG in differing circumstances have the power to appoint independent prosecutors. And
Well,
if,
there are two
Mhm.
circumstances.
Sure.
And I don't mean to interrupt you, so I don't-
Please.
But there are two circumstances.
Mhm.
The first circumstance would be if the elected district attorney were to declare a conflict and request a special prosecutor.
Okay.
In that case, the district attorney himself is finding a legal conflict that he's transferring his.
I understand.
In
And
case-
one could argue that, if, to follow your line of thinking, that district attorney cannot pass on, if we cannot pass on to the district attorney, if we cannot pass on to the special prosecutor the district attorney's responsibility, how can a district attorney pass on his responsibility as well?
Because it's constitutionally our responsibility.
Mm-hmm.
It is our responsibility. And the difference of the special prosecutor in the APS case is that school boards and school board members are not constitutional officers whose duties and powers are determined by the Constitution. Therefore, they're subject to statutory law, which is what this body does. And this body passed a law that allowed the governor to do that.
Well, I still, if the legislature cannot give the district attorney's powers away, how can a district attorney give his own powers away? That's a concern of mine.
Well,
It
because
does-
they're mine to give, I guess is the best
okay.
answer.
All right, thank you.
All right,
There's one last point I'd like to make.
okay, summarize.
Well, there's been a lot of talk about close relationships and special treatment. There are 20 district attorneys here today. 19 district attorneys in this office have prosecuted police officers from offenses ranging from murder to sex offenses to drug offenses to theft offenses. I myself have prosecuted a police officer and sought the death penalty against him. The presumption of this special relationship is not borne out by the evidence. And we would ask you to consider that when considering the amendment.
Thank you very much. Next, we have Howard Sill with the Sheriffs, Georgia Sheriffs Association. Good afternoon.
Thank you, Mr. Chairman, Senators. I'll be brief. I've been a police officer all my life of some sort, but I was raised by a district attorney. The man who raised me wasn't my father. He's who I consider my father. I grew up in his house, and he was the district attorney in the Okmulgee Judicial Circuit. And the story I'm about to tell you was at a time when we had one district attorney, one Superior Court judge, 8 counties, no state courts, and no assistant district attorneys. His best friend was a man named Henry. When I say it was his best friend, I mean this was his best friend. This is the man who went bird hunting with him, the man who went fishing with him. This is the man who went to every Georgia ball game with him. And Henry got drunk one weekend, and Henry beat up on his wife. It never entered into my father's mind that he would recuse himself. He never thought of recusing himself. That would have been an admission that he couldn't follow his oath. He prosecuted Henry. And back then, we had a county camp, which was a serious penal situation compared to the corrections of today. And if I remember the story right, Henry ended up doing about 6 months for simple battery at the county work camp. It never entered into his mind that he wasn't supposed to prosecute his friend. Henry didn't have a place to live when he got out of the camp, and he lived in the basement apartment of the house for a while till he got back on his feet. He never engaged in any other criminal activity that I know of the rest of his life. I'm here on behalf of the sheriffs, and we worked long and hard, everybody did, on this bill. The first issue that all police officers demanded was the transcript. Absolute necessity of the transcript by a court reporter, nothing less than a certified court reporter, so all the world could see what went on in that grand jury proceeding. And I don't know any more accountability there could be than that. The requirement for a special prosecutor statutorily says that these ladies and these men cannot and will not do their job, will not follow their duty. And as Mr. Porter said, you know, they prosecute officers every day all over this state. And it just doesn't bear out that they won't do it in these cases. We think this bill, the way it was before the requirement, addressed almost every issue people had, at least that came to us. And it's a draconian change in what our present law is today. And I think it supports, well, I think we should leave it as it is.
Thank you. Do you have a question?
What county the sheriff represents?
I'm speaking on behalf of the sheriffs, but I am the sheriff of Putnam County.
Okay. Thank you very much.
Thank y'all.
Next, Vernon Keenan, GBI Director.
Mr. Chairman, members of the committee, as Director of the Georgia Bureau of Investigation, I support House Bill 941 as it was passed by the House. I do not support the requirement that there be a special prosecutor appointed in the officer use of force cases. The GBI investigates just about every one of the cases that occurs in the state of Georgia where an officer uses force that results in fatality or serious bodily injury. Since this legislature has been in session, we've had 21 cases that we have investigated. Now, GBI each and every day works with every one of the district attorneys that are in this room. We work with them on all manner of criminal investigations and prosecutions. Child death, child abuse, public corruption, drug enforcement, murder, rape, sexual assault, on and on and on. We have a very strong working relationship. They rely on us, and we rely on them for input on legal issues. The officer use of force cases are no different, other than we have a tremendously high-profile type of incident that everyone is interested in: the public, the media, the officers themselves, the community, on and on. It is our experience that the local district attorney who is elected by the community is the proper one to handle all manner of investigations, including the officer use of force cases. We work with the special prosecutors when they're appointed or when the local district attorney recruits themselves. Our experience is that it works better when we're dealing with the district attorney who is directly answerable to their community. The special prosecutor, as GBI experience it is, I don't know who they're accountable for when it's all over with, perhaps, but during the process, it's much smoother for us, and we're averaging 2 cases a week of the officer use of force cases to be able to go directly to the locally elected district attorney, have them involved in the process from the very beginning, because GBI does not work these cases in a vacuum. It's necessary that we have ongoing and immediate discussions with a competent prosecutor to give direction in certain legal areas and to assist with the preparation of search warrant and going through the maze of the technicalities that become involved when you have a controversial police use of force case. So GBI's position is we support the local district attorney handling these cases unless they decide to conflict themselves out.
Thank you. The next person we have is Sir Maejor with Black Lives Matter, Atlanta chapter.
Thank you, Mr. Chairman and members of the committee. My name is Sir Maejor, the president of the Greater Atlanta Black Lives Matter chapter, and I'm not going to be too long. I wanted to say a few things. First of all, thanks to all of our law enforcement that is present today, and also the DAs. I would like to give a special thank you to District Attorney Robert James out in DeKalb County for being one of the first people to indict a police officer who killed a unarmed, naked veteran. His name is Anthony Hill, and so I thank District Attorney Mr. James. I'm going to kind of reiterate what I've already said, and I'll be really brief, is that we cannot have a double standard in the law. I think Georgia law is quite clear, and also the United States Constitution is quite clear when it talks about equal protection underneath the law. You simply cannot have law enforcement getting special treatment or preferential treatment versus our ordinary citizens. It's simply not fair. It's not morally right. Ethically, I think it's a conflict. And I ask that, you know, we take a look at this and make some amendments. When you talk about, I heard that some folks from other chiefs associations and the sheriff's associations, where you talked about they had all the stakeholders get together. All the stakeholders didn't get together. Members of law enforcement got together, and members of and district attorneys got together, and then they crafted this bill that single-handedly destroys our fundamental Constitution. When you have a bill that only protects the personal interests of law enforcement, that is not fair to the average citizen. You're saying that law enforcement can have these special treatments, and the ordinary citizen doesn't get that, or the family will be at a disadvantage. And so I ask that we relook at this, although I do think that this bill is a step towards something tangible, something that's more effective. But you have to sit down with all of the stakeholders, meet with members of the black community, meet with clergymen, and meet with the law enforcement and our representatives, and then we collectively craft a bill that is suitable for all parties. I know Mr. Garland is going to speak to some other aspects, the more detailed things that I'm not more experienced with. I'm not a paid politician. I'm not a professional lobbyist. I'm here as a member of the community who has spoken to the people who are on the receiving end of this bill. You have to be honest with yourselves. And to my members of law enforcement, you got to say, well, although this bill protects law enforcement, you have to look at who's on the other end of this bill. And that is a lot of black people. And let's just be honest, poor white people, people of minorities. Oftentimes the people that come in contact with law enforcement are black people. The people who have been shot and killed that were unarmed are black people, majority of the time. And so we have to look at this bill and figure out how we can collectively come together and craft something that is going to be effective for all parties. Thank you.
Let me ask you a question. Would you be willing to work with members of this committee over subsequent improvements?
That's a very great question. I would be delighted to be charged with that. I've taken the initiative to meet with some of my my law enforcement counterparts, and I think that we should come together at the table and let's do that.
Thank you.
Thank you.
We have a question. Well, I thought we had a question. No. Thank you. That's all.
Thank you.
Erica Williams.
Hello again, and good evening. You know, I'm always brief when I come here. This is the third time I've been in the House. I'm here in the Senate. I'm saying the same thing. I was happy. Thank you, District Attorney, people, for coming and making those really rough, feather-ruffling decisions sometimes. We appreciate that. I'm glad to know that we're all on the same side of wanting a court reporter there in the hearing.
So you support that?
I do support that, but I also want it to be mandatory, not at the district attorney's discretion to have one, for it to always be there. Secondly, I came here because I wanted to talk to Mr. Bethel, but he left out. Because last time he kept asking, is it better now, or or is it better to just change a little bit rather than do nothing at all? And my answer is, it's better to do nothing at all. And I know that sounds like, why would she say that? Because when it was created, I understand that it was probably a lot of people creating it that didn't have everybody's best interest at heart. But today, in 2016, I feel like there's enough people here who understand how the entire world works, and we're able to get a more fair bill and a more fair representation of transparency. And that's why I think, just wait. Just say no today or tomorrow, because I'm not going to be here. I'm going to D.C. because I'm going to fight for Flint. I'm from Flint. And now we're at a place where the citizens, people are looking at you guys. We know what's going on. We see how the law works. So we just ask, take a minute. If you can't do it this time, maybe, it's okay. Just wait. Add in the special prosecutor if you can. I know there's different things, with nobody's saying you guys can't do your job. But like his dad, sometimes it's hard because those are your friends. There's the people who supported you, so you don't want to necessarily turn your back on them, and that's a hard decision. So rather than looking like you can't do your job by having to recuse yourself, then just let somebody else take. It's just too difficult. Sometimes it gets too sketchy. Y'all all work together. But I still appreciate y'all. Thank you. So yeah, that's it. Just wait.
Thank you.
You're welcome.
Last person signed up is Garland Favorito. Is that?
It's close enough, Mr. Chairman.
You were here last time.
I've got a handout, 5 copies.
Sure. Just give them to Ms. Yeomans.
Thank you, Mr. Chairman. I'm going to focus exclusively on the sub bill that you have before you. Actually, I think there's about 3 of them now, so I'm a little bit confused. But the one that I looked at, I'm going to talk to that one a little bit. It had to do with the special prosecutor. I don't want to quite get into that debate, but basically, I just wanted to mention to you that House Bill 941 was put together by the special prosecutor who investigated the murder of David Hooks down in Dublin, Georgia. It's essentially the same, a lot of the same procedures were used, and that did not return any indictment whatsoever in that case. Now, we believe that there probably should have been at least a probable cause for a faulty warrant. I'm not going to criticize the special prosecutor because he's sitting behind me right now. So, but a special prosecutor is not going to necessarily create the objectivity that we really need. And a special prosecutor or not, or district attorney, is really a diversionary issue. The real issue is what's in this bill and the way that it subordinates a grand jury legally to a prosecutor, whether it's a district attorney or a special prosecutor, that they have a vested interest and quite often in not prosecuting a officer, as we've seen so many times before. In fact, we knew that the David Hooks investigation would not return an indictment, and actually even went to the Attorney General about it before that investigation even started, as soon as we knew who was appointed. So what do really the voice of the people want? What do we actually are looking for? There's a couple of issues. As if you remember,
Excuse me, do you represent a group?
Well, founder of Voter GA.
Okay, Voter GA.
Yeah.
Sorry.
So But what I wanted to mention, basically, first of all, we talked a little bit about the unconstitutionality of and the lack of equal protection, the double standards that exist in this bill. I sent you a list. There's about 10 or 12 different double standards. This bill creates an entire new set of double standards that I believe violate equal protection clause. Now, what I would like to hear from the Legislative Council when we're done, before the vote, or if there is one, whether or not this bill is constitutional. The other issue that was raised has to do with the General Assembly's power under Article 1, Section 1, Paragraph 11 to legislate grand jury procedures. The only procedures that the legislature can currently authorize are jury selection and compensation according to the Constitution. So I would ask Legislative Council, is this bill constitutional? I'd love to hear her go on record before this session ends. So what we're really looking at here, and I have to commend Senator Crane. I think he has really the real issue, the answer to this problem, and that's what the people want is equal opportunity, equal protection for all. So the simple solution to that is to strike down the 6 paragraphs that Senator Crane mentioned in 17752, and I forget the other clause right there, but I think I've got it on the handout. That would solve the problem. Then we're on an equal footing for all people. And we don't want to end up with a civil grand jury investigating a criminal investigation. That is what is being proposed here. You have a whole new set of double standards. So the special prosecutor issue is really a diversionary tactic. That's what frustrates the people so much, because we can't actually address what the real issue is. The real issue is unequal protection and the question of authority. Do you have the authority, even the authority to make these laws when the Constitution prohibits that? So I appreciate your time. Y'all have been very, very patient. Thank you, and I wanted to be brief because we're at the end of the day. So thank you very much, Mr. Chairman.
Thank you.
I would be glad to take any questions.
No questions. Thank you.
Could we hear from Legislative Council on whether or not it's constitutional?
Maybe, but not today. All right. Thank you very much, everyone, for being here today and for contributing to the process.